Lordships,
Which judge? Yes. So, interim order passed by DRT is violated, so remedy is writ petition. Should you not approach DRT?
yeah, interim order has been given by the DRT.
If it is violated, then whom should you approach?
The appellant.
The person, see, mister, if we grant an interim order in your favor, simple thing, you understand all this time wasting tactics. If we grant an interim order and it is violated by the state government, GP revenue, you don't go to Supreme Court saying that High Court had granted, it is violated. You approach the authority whose order is violated. Simple.
So the same way we directed.
Not directed. You withdraw with the liberty, otherwise we will
No, no.
dismiss. We cannot entertain the writ petition for
I also-
violation of an interim order passed by debt recovery
I
tribunal.
also filed an application seeking before this, my lordship, seeking for a direction where the property was being belongings of the tenants were being seized on the same day, on 31/7/2023. In spite of the orders were been sent.
Your remedy is, mister, we are not sitting here to advise you. A very good thing, file a writ petition, ask the opinion of the court and then say that the court has directed me to approach DRT. Huh? It's not, we will dismiss it.
At least a direction may be passed, lordship,
Nothing.
for the belongings that were been
No.
seized by by the advocate commissioner,
No. No.
by the respondent number 2.
Whatever you are urging
Wait,
here, you
this-
can urge
madam,
before the
this-
DRT, saying that the attachment is only in respect of the movables. I have attached my immovables.
Heard on
I
the,
need to take out my movables,
heard on the question,
whatever it is.
heard on the question of admission. In this writ petition, comma, the petitioner inter alia has sought a declaration. What did, sought a writ of man, how they wrote, right, we don't know. We are going to ask you one question someday. Mandamus, how does it write for inaction? You all have read mandamus, writ of mandamus in your LLB courses and every day thereafter. C has sought a writ of mandamus or direction declaring the action of bank in not considering request for breach of order dated 9/8/20, order dated what?
31/7.
Order passed in SA number, you don't give the date also.
31/7.
31/7/2022 passed in SA number 314/2023. Paragraph after hearing the counsel for the petitioner at length, comma, we are of the considered opinion that the grievance of the after hearing the learned counsel for the petitioner at great length, at length, it is evident that the grievance of the petitioner in this writ petition is with regard to violation of interim order dated 31/7/2023 passed by the debt recovery tribunal. Heard on the question of admission, petition is admitted for hearing. Yes. Yes.
Your lordship, small submission.
Heard on the question of admission, petition is admitted for hearing. Item
Connected matter, Your Lordship.
7, no?
Connected matter, this
Seven.
one, 6th September. So item 6, Your Lordship. Item 6, connected matters listed on
List
6.
along with WP. Then nothing is going to happen. This is
Your lordship,
admitted
small
for hearing.
submission, your
Yes.
lordship. With respect to item number 5. Lordship, I may permitted to take out personal notice on the 7th respondent counsel, your lordships.
5,
Your Lordship.
So six, Mr. What five?
Item number 5.
Admit. Admit notice, personal notice, yes, that is always there.
No, Your Lordship.
Personal notice and proof of service, that without saying.
No, Your Lordships. I'm saying, Your Lordship. I'm saying that.
No, we should hear you for half an hour, right?
No, only one
Please
second.
call, madam.
Petitioner's
Which number,
call, Your Lordship.
item number? Which item, Mister?
Item number 5, Your Lordships.
He says five.
I'm seeking a permission from the Honorable Court to take a personal notice on the respondent's counsel.
No, that business we don't engage in. No,
Council not
sorry.
take out.
Prayer for service of notice on counsel for respondents is rejected. Yes. Every little thing you want rejection, right?
No, not rejection is not required, Your Lordships.
No, the problem is if we dismiss the petition, there is a problem. If we admit, then also there is
No.
problem.
Depublize, Your Lordships.
Ah. So what? All backdoor entrants like Uma Devi, what regularization, Mr. How have you been gotten into the service? Sanction posts are there? Not there. Were you subjected to process of selection?
2005 through proper channel.
Huh?
Through proper channel.
Proper channel
Proper channel.
against sanctioned post.
Your Lordship,
Admit.
kindly see the 105 for a movement, Your Lordship.
Admit notice.
But Your Lordship, in this matter, this got as a recommended for regulation, Your Lordship, to the government.
Regularization of services or persons appointment.
Government may which is madam, which case this is
7.
admit.
May regularize.
Give that file 7. The issue involved, the petitioners are contract employees of judicial department. In this writ petition, the petitioner seek regularization of their
Your Lordship, this got recommended to the government to regularize the services. Even in
This
spite
is
of the
Pending consideration before the Honorable Supreme Court.
problem.
it is for admission. You want it to be disposed of, right? Without notice to them, and you want that they should go to Supreme Court and seek stay. That without hearing us, an order has been passed. What is this, Mister? Others are waiting, Mister. These are all matters which we ourselves are, despite that you are interested in wasting time of the court. Yes. Okay. What is the
Yeah.
evidence, Mister,
Let
that it is this thing? Scheduled land.
schedule. This the writ appeal is filed against the order.
No, that is all done.
Yeah.
We know we will dictate the order. We are answer only the query. Why it is this thing? Why, how does it falls within notified agency area?
Yes, my lord. This area.
Which notification? Where is that?
Yes, 11.
There is a finding, right?
My lord, in the
Page
latest.
15.
My lord,
Read page 15 if you have not read it here.
Yes, I read.
Today.
I read.
You read it
Now.
today. If you have not read the
Yes.
file at home,
No, my
read
lord, I read it. On the basis of the
page 15.
15, I am reading, my lord. This said the interim order is continued by order dated 4/6.
No. Having regard to.
Having regard to the same, in the absence of any record to the show that the land is falling in the Mangapeta Mandal or included in the notified agency area. The stand taken by the official respondent that based on the communication received from the director, the subject lands are treated as if falling in the agency area is without any legal basis. In the absence of any notification issued by the government of India, notifying that the subject lands are falling in agency area, the communication cannot be the basis for saying that the subject lands are falling in the agency area. The relates- Yes,
One second. Earlier, if you see 1950 order, all villages of Paloncha Taluk of Warangal district except excluding Paloncha, Burdumpad, Asharapet, Brahmapet, Kukulur and Nelapak villages and 2 is Samsan of Paloncha are excluded.
Yes,
Merely because these villages now are taken out from Paloncha and are included in Mulugu, They do not lose their status of a scheduled area.
That's true. By reorganization of the districts or by the, that's true. But this was, this matter,
No,
is
sir.
then covered by, this
What-
matter here.
1 minute. What is the material to show that simple, this village is within the scheduled area, notified agency area? Tell us.
Will at this matter in respect subject to law.
Yes.
These 23 villages, whether they fall within the scheduled area or not, extensively dealt with by this honorable court. My lord, this will, your lordship may kindly say, extensively dealt with. How this,
No, it falls or not. What is the material?
my lord, on the basis of the material only, my lord. On
The learned single judge has recorded a finding that you did not place
yes,
any
that is
material.
what, my lord, learned
Did you
single
file
judge-
this before learned single judge?
Just a minute. Just I should dispel doubts. Learned single judge, on the basis of an interim direction granted by this honorable court, in a matter pending before the division bench, this order came to be passed by the learned single judge. Learned single judge, in the same order, referred to an
So
interim.
then what is the final order?
Final,
Come after, Mr. We are perhaps quick then, you realize.
I'm coming to the point.
So then you say that interim order, then what final order? You are
Final
not
order
telling
is-
us.
Final order came to be passed by this division bench, holding that these 23 villages fall within the schedule area. This
Where is-
final order,
Which paragraph?
yes, Melody, you know, your lordship may kindly come to para numbers 18,
Which?
page number 27, para 18, had extensively dealt with this issue. Melody, the learned single judge has considered this aspect in proper perspective and after correlating the Government of India Act 1935 and regulations made.
Which village? Where is the finding that Mangapet village is in share?
Yes, Millet, in 23 villages, Millet.
Where is it?
Millet, the para at 7 Millet, para 7 at page number 4. The lordship may guide. In the division page, page number 4 Millet.
Only on admission. We did admit that. Mr. Additional Advocate General, you are only arguing on admission, not final hearing. Heard on the question of admission.
Exactly, I have answered.
Exactly, no. So therefore, within 1 minute, you should conclude that, sir, this village has been held to be
Division bench of
falling
this
under by division bench of this court. One sentence is enough.
That's what I was
You
about
are
to say.
saying that I am coming.
I was about to say that only Millet, your lordship directed me to read paragraph so and so. That's why I have to follow what your lordship
No,
says.
no,
Millet.
not follow. We thought that perhaps you have not gone through it.
I
That's
thought
why we said
that
that please read it.
Before
That
let-
single, you should, what two sentences additional Advocate General? Learned single judge has said that there is no material to hold that this thing is in notified area or whatever agency area. The division bench in para 15 says it is within agency area.
yeah.
That's it. Two sentence.
Millet,
Huh?
yes. Millet,
This
true.
art of brevity heard on the
Well, before passing order, I'm appearing for the unofficial
not
respondents.
passing any order,
They are admitting.
admitting.
So blessed. Oh, blessed.
You have filed the KVA?
Yes, well, in fact, I filed wakalat for Mulod respond numbers 1 to
KVA?
3. Keep it. I'm sorry, Mulod, I have never. Oh, blessed.
Don't, I mean, advance copy does not authorize you to oppose admission until unless he is making factually incorrect submissions.
Oh, blessed.
We have to, why we are hurrying up, mister? We are seeing the faces of MBBS NEET aspirants, their results, and they are seeking admission. That is why. Otherwise, we can hear you. He could have argued for half an hour. You could have replied for till 1:30. We would have been very happy. Thereafter, at 1:30, passing an order admitted for hearing.
While filing writ
They would have
appeal,
been over.
filing writ appeal, the council on the requisition is served the notices, Mulod. That is the procedure. Applying to Lordship's notice.
We are trying to.
So that is why I'm Mulod before the Lordship's Mulod.
Sir,
Otherwise,
1 minute. What we are trying to tell you is our approach, because you may feel, no, why the court in a hurry? We are in a hurry because there is a bunch of MBBS students seeking admission. It is to be heard today. So therefore in a hurry, otherwise we would have heard you leisurely. That's what we are saying.
I leave it to lordship. So wait, my lord, just.
Heard on the, and this is admission, your not your appeal. His appeal, admission between him and court. Heard on the question of admission. Appeal, this intra-court appeal has been filed.
Move the application, move an application for fixing an earlier date, will.
Learned counsel for respondent may file counter to IA 2 of 23 within 3 weeks. Yes.
Obliged.
Yes, madam.
May I please, Your Lordship, sir. Let I am appearing for the contempt of let.
Contemner of appellant. Ah,
Let
So-
the
Proceeding on the same basis, he again asked it. Mr. Sanjeev, last
Right.
time we told you that unless until fresh material, not on the same charges, you cannot initiate fresh proceedings.
may I make one submission. Your Lordship may kindly see, now that it is complied with, I'll show it to Your Lordship's.
No, no,
what
but you,
complied with?
At the order of the learned single judge, it is at page 41, para 7, Your Lordship may kindly see.
No.
Page
So
41.
only after punishment in contempt you will comply.
Even prior to that, there is I'll just make one submission quickly.
No, no, Mr. As we understand, we'll tell you we are trying to save time today
Correct.
because of medical students,
yes.
right? We are trying to tell you is that this appeal is under section 19 of Contempt
Yes,
of
ma'am.
Courts Act
Yes, ma'am.
against order by which you have been you have been held responsible for
And there is-
contempt, and a fine of rupees 20,000 has been imposed on
Yes,
you. So your submission is that it has been complied with.
it has
So that does not mean that you did not disobey it. Learned single judge has directed in a writ petition 18611 that the order of compulsory retirement be set aside
yes, ma'am.
and petitioner be directed to be reinstated in
Yes.
service and to pay 9 months salary to him.
Yes, we have paid, my lord, even
Just a
before.
minute, just a minute. The learned single judge has said that thereafter you have reinitiated the DE on same charges, this thing. So that has been held to be willful disobedience and 20,000 rupees fine.
Let,
So how is it, have you withdrawn this reinitiation of DE on the same ground?
let the learned single judge said that let the complaint copy is not furnished to him. Millet, there was no complaint, Millet was the impression Millet gathered. Millet, there was a complaint, Millet, complaint has been given to him.
No. What is your case in appeal? You did not reinitiate the DE against
We
him?
have reinstated because there is a liberty granted by the learned single judge to reinstate. Page 47, page 41, para 7, Millet, that is the reason. Millet, I'll,
No. 1 minute. 16/8/2022 direction was passed
yes, Millet.
by learned single judge.
Yes, Millet.
When have you reinstated?
Millet, we have reinstated, Millet, on 21/9/2022, 28/6.
1 month, 1 minute. This order is 5th June 23. So you have reinstated when
21/9/2022, Millet, reinstated.
20,
21/9/2022, Millet,
and
reinstated.
salary.
Salary has been paid, Millet, on 28/6/2023.
Milord, I contradict this.
1 minute.
Yes.
Court is with you. I mean, we will come back to you after. Yes.
Thank you.
Millet, the direction is threefold, Millet. First direction is to reinstate. That has been done, Millet.
Pay the salary.
This pay the salary is also, Millet, complied with. Millet, there is a finding by the learned single judge that salary has also been paid. In the contempt order, Millet. Page 11, Millet, 2 lines, Millet, I read. Page 11, Millet. Page 11.
Yes.
First line, Millet. Having para 4, having regard to the rival contentions, this court finds that one of the direction of this court payment of salary after being reinstated into service has been complied with by the respondents. However, with regard to Millet, furnishing of the complaint copy, Millet, that was not done, Millet, inadvertently. Now, Millet, it has been supplied. I have filed the material paper. The contempt was also initiated only for non-payment of, Millet, the wages.
So your case is not a willful disobedience.
Yes.
First sentence.
Millet, the
Milord, they are simply wasting the time of the Honorable High Court, Milord. Kindly see, Milord, 18/6/11 of 2022 orders, Milord. They were challenged in contempt case, Milord. In page number 32 to 42, it is clearly written, Milord, that there are 3 parts.
Please go to para 7, read 4 lines.
Yes,
Para 7 at page 41,
yes, Milord.
read 4 lines.
Milord, direct the respondent to reinstate the petition.
However, 4th line.
However, liberty is also given, Milord.
Yes. But read.
The ending lines, Milord, that
Please read. Liberty is also given.
liberty is also given to the respondents to take action in accordance with law by providing reasonable opportunity to the petitioner if there are any complaints against the petitioner. Milord, that complaints against the
So this
petitioner.
interpretation is it should be a new complaint, not the old complaint.
Yes, Milord.
That is what we understand.
Yes, Milord.
All right. Yes. Anything else? Anything else?
Milord, they have clearly disobeyed the order.
Fine.
Obviously.
This appeal under section 19 of the Contempt of Courts Act 1971 has been